So yes, in the last class we were discussing about the maxim or the defense of volenti non fit injuria. Okay, that you cannot put yourself in the way of harm. Okay, and then complain about it. Okay, that you cannot consent to being harmed and then later on complain about it. So we discussed a couple of cases, and then we were discussing about sports, like for example boxing. I gave you example of what happens in case of games and sports. So you know that. That in case in any game, so for example, forget about boxing, not just that. Okay, when you play cricket, okay, relatively less aggressive form of games. Okay, mm, when a fast bowler bowls, okay, there's a bouncer, then there's a high possibility that it hits the some body parts of the batsman. Okay, batsman gets injured, and the batsman then take the bowler to the court and then say that, well, uh, I seek damages for what you have done to me. So yeah, that's not the case. Okay, now even when the bowler hits directly, okay, unless it's deliberate, okay, so it will be determined. Okay, so mm, as long as players play within the rules, okay, this maxim kind of applies. Okay, in the sense that you consent to that level of harm. Okay, you take the risk. Okay, so once you take the risk, that then you cannot complain about it. Now for example, one bowler clean bowls you, and then out of rage, out of anger, you take the bat and hit the bowler. Well, that cannot be considered as part of the game. So in such case, obviously you can take the other person to the court and seek damages. So I hope you understand what is the case here. Okay. Well, when it comes to, I think, when it comes to surgeries, done. Okay, even in that situation, okay, patient kind of consents to being treated. Okay, and when the surgery happens, okay, doctors have to cut you open. Okay, as is the practice, standard practice. Okay, in the profession. Okay, so in such case, obviously you, because you have subjected yourself to this danger, so you cannot later on complain about it. But then but then the thing is that if for example you go for appendix surgery, okay, but the doctor ends up removing your parts of a separate different part of your body. Okay, cuts you open at some other part of the body. In such case, cannot say that, okay, well, you have put yourself in the way of this harm. So you have consented to being harmed this way. So obviously that cannot be a justification for the surgeon. Okay, so we have certain rules laid down. This we will discuss in detail, okay, later on in the case of negligence. Okay, so I will skip that for now. But you I hope you guys have some broad idea as to what this maxim essentially means, that you consent when you consent to being harmed. Okay, then you cannot say that, okay, I have been harmed. Okay, so as is it was said in Smith versus Bakers, that the maxim is founded on good sense and justice. Okay, one who has invited or assented to an act being done towards him cannot, when he suffers from it, complain of it as a wrong. So a surgeon can practice some surgery, do some surgery on you. Okay, and while doing surgery, there is always some kind of reasonable risk, isn't it? The surgery, some lots of distractions I get these days. I think results are out, so some students have some queries. So I'll revert later on. So yes, I hope you guys understood. Okay, so when there are certain surgeries, okay, which are conducted, okay, even those surgeries have to be done as per the accepted practice. Okay, so it cannot be done negligently. So as I said, I'll deal with that specific issue later on. But if the surgery has been done, okay, reasonably, but nonetheless, okay, you suffer some, harm, okay, not because of the negligence, absolute negligence on the part of the doctor. In that case, well, you cannot say that, well, I have suffered, because you have consented to being, subjected to this, procedure. So yes, I hope this is clear. So after that, we can take up one more very important case. Okay, so this it is by the name Ulrich versus Sumner, 1962. I'll just type it here. So yes, in this particular case, it was said that a person, okay, so in this, a person attending a game or competition takes the risk of any damage. I'll also share the link to the case to you. Just a second. Do you see the link? Are you able to see the link?
Yes, sir.
Okay, see if it is active yet. Otherwise, I'll have to type this whole thing, but it's better if you're able to get it there. For me, the link is not working, so I'll just send you guys the quotation, not quotation, the quote. Okay, so here's it. Okay, I think it's loaded. So the quote goes like this. Okay. So it said,
the link is working.
It's working. Okay, so you're able to open the link. Okay, so you look at the cases. Okay, the gist of the case. Okay, what had happened in this particular case? The claimant was a photographer. Okay, working at in a horse show. He was situated within the ring where the horse show took place. Okay, rather than behind the spectator barriers. Okay, when one of the horses galloped towards him at a significant speed after the rider lost control of it, knocked him down, the claimant sued the defendant in the tort of negligence. Okay. So issue here, if negligence is established, a defendant may still avoid liability by raising the defense of volenti non fit injuria. So whether that is available or not. Says, so you know what this defense is all about. Okay, so the issue was whether the defense applied in this case. Okay, given that the claimant was within the ring rather than behind the protective barriers. So it was held, okay, by the High Court there that the defendant was not liable. Okay. Now, why is that the case? Why did they find that? I have sent you guys the quotation, the quoted marks, quoted statement here. A person attending a game or competition takes the risk of any damage caused to him by any act of a participant done in the cause of and for the purpose of the game or competition, notwithstanding that such act may involve an error of judgment or a lapse of skill, unless the participant's conduct is such as to evince a reckless disregard of spectators' safety. So you see what is being said here is that the defendant is not liable. Why? So think about it. Okay, you are the rider of the horse. Okay, you try your best to keep the horse in your control, but you cannot possibly ensure that the horse will in fact remain in your control. Okay, to avoid harms to the spectators, they have created the barrier. Okay, now it is possible for the horse, okay, for the rider, despite her best what should I say, expertise, that the horse nonetheless gets out of control and ends up harming someone. Okay, in such case, the fact that you have put yourself in the way of danger here will be a sufficient defense. So yes, that's essentially what has been said here. So you see that it says the High Court held that for the defense of Volenti non-fit injuria to apply, it was not enough that the claimant consented to generic risk of injury. Rather, the claimant had to consent to the lack of reasonable care which produced the risk. Okay, this requires the claimant to have complete knowledge and understanding of the extent and nature of the risk. In the case of sporting events, however, spectators can be taken to know of and consent to the risk of the sportsman making errors of judgment or skill, given the fast-paced nature of the activity, unless the sportsman was acting with deliberate or reckless disregard of the spectator's safety. Okay. Now, if the horse rider were to deliberately, take turn and ride among the spectators, then obviously we'll say that okay, this is not a case. This will not fit the case. Okay, so that the defendant will have no excuse then. Okay, but if it was something which is required within the sport, okay, so if there are certain aggressive forms of sports, okay, so for example, in football, quite often you see the footballer kicking the ball outside, okay, so in such cases it's very likely that the ball goes and hits some spectator. So if that's how it happens, then the excuse will be taken by the court. But if some footballer just for no reason kicks the ball at a spectator, okay, just to harm that person, in such case the excuse will not be considered by the court. So it's quite clear. Okay, so some risks are inherent in a particular sport. Okay, and if someone suffers because of that inherent risk, okay, in such case then you cannot complain, because you have put yourself in the way. Okay, as a spectator you have put yourself there. Okay, so you consented to some kind of reasonable harm. So then you cannot later on complain about it. So that's essentially what has been held in this particular case. But one thing is that Volenti non-fit injuria does not mean scientific not non-fit injuria. Okay, so what does that mean? Scientific non-fit injuria, that essentially means that okay, you cannot possibly know of everything that might happen. Okay, so you do not consent to everything that could possibly happen. Okay, so we would discuss in this context the case that I had referred to earlier. Okay, so I'll just send you guys the link. Click on it and you will. Yes.
So if the person getting hurt is not a spectator, so for example, if he is passing by a cricket field and
okay, so yeah, so that's a very interesting question, and we will discuss this. Okay, we have a case on this. Okay, that we will discuss. Okay, it depends. Okay, so for example, you are to play at some place, okay, where you have to take the safety of passerby. Okay, now if you're playing cricket right adjacent to a highway, okay, and or some footpath, and people walk by there, and you are not supposed to be playing a risky sport there, and you end up by virtue of that end up hurting someone, then that other person will obviously have a claim under the law. Do you understand? Suppose you are playing cricket right adjacent to the road, okay, and there are passerby there, and you end up hitting so hard that it goes and hits one person, then obviously that person will have a claim as against you. So you are supposed to play somewhere where there are very less chances of someone getting injured. So you play somewhere. Quite often this thing happens, as you know. We grew up, okay, with the similar kind of experience. So we would go and play cricket somewhere, and then one amongst us, okay, will hit, and then it will go and break someone's glass. Okay, that person will obviously have a claim as against you, because that's that person did not consent to his property being destroyed by your game. So obviously that is there. But we are talking about a setting. Okay, so for example, you have here in this university, you have a stadium, okay, where you play. So anyone who goes and watches the sports there, obviously takes that reasonable risk. Okay, so if you were one of the spectators, you see quite often, okay, a six is hit, the ball goes and hits someone. Okay, so when you buy the ticket and sit there, you consent to that much risk there. Okay. Now there are situations, okay, as you know, some cricketers, okay, they are so extraordinary, extraordinarily strong that they can hit a six and it will just go outside the stadium and hit someone. Okay, so we have an interesting case, but we will deal with that at an appropriate, place when that specific topic comes. Okay, so I hope for now just bear with me. We have that case as well. And then I told you that Volenti non-fit injuria does not mean scienti non-fit injuria. Okay. Now, what is scienti non-fit injuria? So basically, see, you cannot possibly foresee everything that could, possibly happen. Okay. So the risk that you take is only of certain kind and not of other kinds. Okay. So that's essentially what it says. Okay. And so when you take certain risks, you take those risks, okay, which you can know that, okay, these are the possible risks, and I'm consenting to it, okay. You do not consent to every other risks, okay. So in this context, we have a important case here, okay. I have shared the link. I hope you are able to click on it. It's by the name Smith versus Baker and Sons. If you remember the quotation I had, shared earlier. Okay, the facts are like this. The plaintiff was employed by a railway company to drill holes in a rock near a crane. Okay, your plaintiff was, employed by the railway company to drill holes in a rock near a crane. Okay, operated by men employed by the railway company. The crane lifted stones and at times swung them over the plaintiff's head without warning. Okay. The plaintiff was fully aware of the danger and he was exposed to by working near the crane. So the plaintiff knew that, okay, there are certain dangers I'm exposed to if I work near the crane. Okay. So what happened was, as was expected, one time a stone fell off the crane and injured the plaintiff. So he sued his employers for negligence under the then Act, Employers Liability Act 1880. The jury in the county court ruled in favor of the plaintiff. Then the defendant approached the Court of Appeal, which reversed the county court. Okay. Then the matter was taken to the House of Lords. Okay. So the issue is whether this defense is applicable or not. Is the defense of volenti non-fit injuria applicable to cases where employee whose occupation is not in itself dangerous, okay, suffers injury from an activity carried out in another department? So as you can see, what the person here was doing, that act itself was not dangerous, but the danger emanated from some other act, that of the crane, okay, in another department of which he is fully aware though, okay, but nonetheless continues to work. So what was held? The appeal was allowed. The mere fact that the plaintiff undertook or continued employment with full knowledge that there is danger arising out of another activity in workplace is not enough to show that volenti non-fit injuria is applicable. Okay. The question of whether the plaintiff has undertaken such a risk is one of fact, not of law. The evidence in the present case shows that the plaintiff did not voluntarily undertook the risk of injury. This is so in common law and in cases arising under. So here's what is interesting here is this, that if the danger was inherent in the job that plaintiff was, doing, that of digging holes, okay, if that was the danger, okay, if that job in itself was dangerous, then obviously this defense applies, that you yourself undertook a work which is dangerous, okay, inherently dangerous in your profession. But then the harm that he suffered was from the work by another department, okay. So he did not consent to that, okay. So it was allowed, okay. So the defense of volenti non-fit injuria was not accepted, okay. Now what is the situation? Okay, so situation is like this, that some certain, under labor laws, okay, different kind of labor laws, okay. The situation generally is like this, that if the nature of the job in a particular factory is such that employees could get hurt, okay, then obviously they are compensated for that. Okay, insurance also exists. Okay, so they are compensated for that. So this is I think rightly, this was rightly held. Okay, the fact that you have merely because you were working in a dangerous site does not mean that okay you consent to every possible harm that could possibly ensue, that could befall upon you. So it's rightly held that only those harms okay which are inherent in the profession, you can say that you have voluntarily taken that risk. But then here's a different question that I would like to add here, different side that I would like to add here, that quite often people do not have much choice in life. Okay, because of lack of alternate employment opportunities, people take risky jobs. Okay, and then they suffer. So then should this defense of volenti non-fit injuria be applicable then? Well, the current understanding is that if any job is dangerous, then the employer has to take all precautions so that such harm is avoided. Apart from that, insurance is also necessary. Okay, so that should such situation arise, okay, the said person is not without any remedy or without any help. So that's essentially the position. But earlier the idea was that you enter into free contract. So when you enter into a free contract, you also consent to all the dangers that emanate from the job that you take up. So yes, that's essentially the point position now. Okay, so as I said, okay, the volenti non-fit injuria does not mean scientific non-fit injury. Scientific non-fit injury, it means that okay, you do not consent to every possible harm that can befall upon you. Okay, only those okay which you can expect to be inherent part of your innately part of your job. Okay, so that's why this case had rightly held in that way. Now there are certain limits. Okay, so one limit we kind of discussed already. Okay, there are certain limits. Okay, to this application of this particular maxim. It is that the maxim is not applicable to illegal act. Okay, so you cannot be party to an illegal act. Okay, you cannot be doing something illegal. Okay, and then say that the other party consented to it. Okay, the fact that the act that you have done is illegal in itself reason enough for you to compensate the other person. Got the idea? So you cannot then say that other party consented to being harmed. Okay, so yes. So an example would be, it is no answer to claim to a claim made by a workman, okay, against his employer for injury caused through breach by the employer, okay, of a duty imposed upon him by a statute. Okay, so if a harm is caused okay to the employee by the breach of a duty by on behalf of the employer, then obviously the breach of duty is an illegality. Okay, so even if the other side okay voluntarily was harmed okay because of some mistake on their part, the employer cannot then say that well volenti non-fit injuria, because the employer's act itself is prohibited under the law. Okay, so yes, you cannot claim this as a matter of defense then. Okay, the next limit, the next restriction upon this maxim is that it has no validity against an act based on a breach of sorry, the example that I gave is of this one, that it is of no validity against an action based on a breach of a statutory duty. So in this particular case, the duty of the employer was created by the law. The fact that the employer breaches the duty, okay, is in itself enough to say that well the claim arises in this particular case, even if the employee has had put himself in the dangerous way. The fact that the employer has breached the duty under a law itself is sufficient, and then in such case the maxim does not apply. Then the third case is of that of case of a rescuer, okay, and that defendants wrongful conduct, okay, creates a situation in which you are compelled to rescue someone, okay. So in such case you cannot say that, well, volenti non fit injuria, that you have put yourself in the way of danger, okay. No, you cannot say that. Why you can't say that? Because it is because of the defendant's wrongful misconduct that the situation has arisen, okay. Had it not been for your act, this situation would not have arisen, and then I wouldn't have to then put myself in the harm's way. Now why is that the case? Okay, people, we are not expected to merely just be spectator of an event in which someone is suffering, someone is in dangerous way. We are also moral conscientious beings, okay. We put ourselves in the way of danger to rescue, to save others, okay. Now while we do so, when the danger is created by the fault of someone else, okay, we put ourselves then in the way of danger and rescue someone, and then we suffer from harms, okay. Then the other person cannot say that, well, no one asked you to rescue, okay. That person cannot say so. What is the reason? Because you have created the danger, because of which I was compelled to be party to this rescue. So yes, important case here by the name Haynes versus Harwood, okay. In the particular case, look at the facts, okay. I hope you can see the link. It says the plaintiff was a constable on duty inside a police station located in a busy street, often attended by many people, including children. The defendants owned two horse van, which was left unattended. So here's the problem, okay. The horses were left unattended by its driver in the same street. The driver had put a chain on one of the wheels of the van that was subsequently broken. For some reason, supposedly because a stone was thrown at the horses, they vaulted along the busy street alongside the van, okay. A police constable saw them from the police station, got out and managed to stop them, but sustained injuries, in respect of which he claimed damages. So the King's Bench here ruled in favor of the plaintiff. The defendants appealed to the Court of Appeal. The question is, the defense was that the police put himself in the way of danger, okay. He put himself in the way of danger, so volenti non fit injuria. So the question was whether this maxim will be a defense for the defendant here, okay. So does the maxim volenti non fit injuria, okay, to prevent on-duty police officers from claiming damages for an injury sustained by consequences of acting whilst being aware of the risk that this involves. So it was held, okay, the appeal was dismissed. The defendants are guilty of negligence, okay, because the horse was left unattended by virtue of, okay. Then defendants must or ought to have contemplated that someone might attempt to stop the horses in order to prevent injury. The police are under general duty to intervene to protect life and property, and therefore the act of police constable and his injuries were a direct consequence of defendant's negligence. And finally, the maxim of volenti non fit injuria does not prevent the police constable from claiming damages for an injury. So that's essentially what has been held, okay. Because of negligence on the part of the plaintiff, a dangerous situation was created, and the police officer here in this in a situation was under a duty to prevent that. While he was doing his duty, he suffered injuries. Now the defendant cannot say that volenti non fit injuria, because it was the duty of the police to prevent the harm, and in so doing he suffered damages. Then the defendant has to compensate for the for his negligence. So that's essentially what was held in this particular case. Now we are already past our limited time, so we will continue with the rest of the defenses in the next class.